Great.
Great. Welcome, Rachel. Thank you so much for being here tonight. Thanks for everybody else out there joining us. This is the very first Family Protection Planning webinar series. This will be a live event every Thursday, every third Thursday of the month at 7 p.m. Each webinar will have different guests featuring attorneys, financial planners, therapists, all discussing topics to help you plan for the future. Tonight, we have the pleasure of hearing from Rachel Sheikh. She is the owner and founder of RBS Law in Arvada, Colorado. Rachel makes estate planning a friendly and approachable topic, not scary, not morbid. Her priority is to make you feel comfortable and not overwhelmed. Tonight, we're going to be talking about the essentials of an estate planning. So these are kind of the baby steps to get you started. A couple of the things that we'll be discussing are guardianship and powers of attorney, planning for emergencies while you're traveling without your children. And she really hopes that you'll take away the importance of not having something in place if something does unfortunately happen. So with that, Rachel, welcome. And we're so happy to have you.
Thank you for having me, and thanks for everyone being here. I appreciate it. I am very big on education, so I love talking about this. This is pretty much all I do day and night. So I just love educating. I think it's one of these topics that can be overwhelming for people. And so I try to just like lay it down in like regular people talk and just make it something that's not so scary. So I'm happy to be here. Just going to open up my screen. There we go. Can you see my slides okay? Perfect. Okay,
Looks
so like
great.
Nicole said, we're going to talk about the essentials, estate planning for families. Here's a quick little agenda. We're going to talk about common myths that we hear all the time, DIY estate planning, guardianship, essential estate planning documents, the importance of capacity and consequences of inaction. So, like, what happens if you don't have anything in place? And then a few takeaways, and then I'm always open for Q&A. So the biggest myths I would say about estate planning that I hear most often from clients, the first is estate planning is just for the wealthy. So a lot of times people will be like, well, I don't really have anything. Like, I don't need an estate plan. But if you have property, if you have children, if you are alive and well and care about your health, like that's enough that you need an estate plan. Maybe you don't need a super complex trust. But as we'll talk about tonight, estate planning can be all different types of documents and include some very basic essentials all the way to the complex. So it doesn't just, one size fits all. However, it is one of those things, right, that like isn't just for people with a ton of money. Another thing we hear is I'm married, so everything will just go to my spouse. Unfortunately, that's not true. So it really depends on how things are titled, right? So if you have a joint account with your spouse, and if you pass away, then that will go to your spouse. But if you have assets in your own name, a house, bank accounts, IRAs, that won't necessarily just go to your spouse just because you're married. The other thing we hear a lot is having a will avoids probate. Um, One of the things, and I will say, we'll talk about this a little later, but probate and estate planning is specific to the state you live in. So if you are watching and you do not live in Colorado, keep that in mind because some of the laws are the same, but some are different. And so in Colorado, having a will does not avoid probate. Having a will is what you use to go through probate. So a lot of times people will say, oh, I have a will, so I won't go through probate. But that's not the case here in Colorado. My family will do the right thing. I always get eye rolls when I say that because a lot of times people just hope their family's going to do the right thing, right? Like, oh, they know what I would want and everything's going to work out. But unfortunately, I always say death and money bring out kind of the worst in people. And so we see so much conflict after that, and families don't always do the right thing. I can't afford to work with a lawyer. That's a pretty common one too, right? lawyers are expensive, but not all lawyers are expensive. And the other thing to keep in mind is, again, right, not one size fits all. So some type of estate planning documents, trusts, and things that are way more complex might be a lot of money, right? Thousands of dollars. We'll talk about some pricing at the end. But oftentimes you can do documents for a few hundred. So just because, lawyers seem intimidating or they seem expensive, that's not a reason to rule it out. Many attorneys, including myself and my firm, offer free consultations. So at least take that first step in talking to an attorney before you decide whether or not you want to hire them. Why not LegalZoom or online software, DIY estate planning? So we see this a lot. And we get this question a lot, right? Especially with all the AI out there and technology. There are so many software programs that will just spit out documents, right? They're going to spit out contracts, they're going to spit out wills, they're going to spit out powers of attorney, guardianships. But one of the things that we see is you don't know, right? Like if that document is legally valid and binding in the state where you are, because a lot of these software programs are national or even international. And so just by plugging in Colorado, you're not really sure that it's going to be in line with Colorado. As I've talked about, one size does not fit all. So a lot of times you'll see like boilerplate documents, and they're not tailored to your needs. So a lot of times they can fail in that way. So even if it is like a legally valid and binding document, without having someone to advise you and answer questions or even ask questions, right? Sometimes when I'm in a consult, I will ask things and the clients will be like, "Oh, I have not thought about that. Oh, I didn't know. I don't know." That's a great question. And so when you don't have an attorney to kind of poke and prod and ask all of these tough questions, then you're not sure if all of that information, which is essential, gets into your document, right? So it might be a good legally valid document, but it might not actually fit your needs. The other thing that we often see is that it fails to account for contingencies. Contingencies are backups, right? So it's basically like if this person passes away or can't serve in this role, then I'm going to name a backup to do that. Or if I want to leave everything to my children, but my children pass away with me, what happens next? So a lot of times we see in the documents that there isn't that next step, like that second or third tier contingency. The other thing that we see is that they're not executed correctly. So each state, right, has a very specific law about how the document needs to be executed to be valid. Some require witnesses, some require notaries. And a lot of times I've seen documents where someone just signs it thinking that everything's fine, but they didn't get witnesses or they didn't get a notary or they didn't sign it in the right place or they didn't date it. So all of those things make DIY estate planning pretty risky. So, estate planning considerations, basically, I like to talk about an estate plan as this holistic view, right? It's not just a will, it's not just a trust. It's basically a set of documents that serves as a roadmap for personal, medical, and financial decisions in case you're incapacitated or upon your death. So, what you'll basically see in a lot of these documents is it depends, right? Like some plans will have trusts, some plans will have, sorry, I'm just going to let someone in. I think I'm the host now, Nicole. Some plans will have trusts, some plans will have wills, some will have all different types of things. So, it really depends on the situation. The other thing that we talk about is it's not just about after you pass away. It is about what happens, like, if you're incapacitated or in an emergency. So they're all different documents that come into your estate plan. The types of considerations that we think about are you legally married? That changes a lot of things. Do you have kids? Are they minor kids? Blended family is something we see a lot. So that's like second marriages, people that have children from a prior relationship. That makes things pretty complicated. But it's also like the way of life now. I would say more than half of our clients come from blended families. And then who do you want your beneficiaries to be, right? Are they going to be minors? Are they going to be people with special needs, people that might not be able to handle their money? And then again, guardianship, right? So do you have minor children that you need to account for? And if you have real estate, those are some main things that we think about. So how do you know which documents you need? Again, this is where attorneys come in, right? We get to talk to our clients, hear their situation, answer their questions, and then make a recommendation on what we think makes the most sense, right? And so it really depends on that specific client's family situation, their assets, their goals. And again, it's not just do you have millions of dollars, but like, do you have assets out of state? What kind of assets do you have? Do you have real estate? So it's really important to kind of work with an attorney to kind of go over those pros and cons and figuring out which documents you need. The most important thing for anyone with a minor child is guardianship. So this comes up, all the time when we work with clients who are parents, and that's usually the time in life that people are thinking about, adulting and getting their estate plan together. So an appointment of guardianship is basically a way to designate a person who's going to take physical and legal custody of your minor children if both parents are deceased or incapacitated. So the important part is both parents. So if you are married and you have kids together, it's unlikely that you would both pass away. But if you are in a tragic accident, that's when the guardianship would kick in. If you are a single parent, the guardianship document does not kick in if you have another legal guardian, right? So, say you and your ex had a child together, you have joint custody. Even if you have primary custody and he just has, a weekend a month, if you pass away, he is still going to be the legal guardian of your child. So you could still designate someone, but that doesn't kick in unless both parents have passed away. The other thing that I should point out is that you have to be appointed by a court to become the guardian. So just because you say in your will that you want your brother to be your guardian and you get it notarized, it doesn't mean your brother just automatically becomes the guardian. The court still has to appoint him. And that's to protect your children, right? And make sure that your brother is able and willing. So the document that you do is either an appointment of guardianship, which is a standalone document, or in a will, you can name the guardian. What happens if you don't have guardians named? We hear this a lot. Basically, it still has to go through the court, but the problem is you don't get to decide who that person is, right? So your family would come forward or anyone would step up and say, I want to be the guardian of this child. Um, Things can go wrong there if it's someone that you don't trust or if it's like someone from each side of the family and there's conflict there. Like I said, it's always part of a plan when we have clients with minor kids. I mentioned this, a standalone document, and that's basically a document that is not in a will. And we do this for two reasons. One, if people are not ready to do a will or they can't afford a will, but they really want to name a guardian, since that's such an important thing, we can do it in just one document. The other thing is it's really easy to update if it's just one document as opposed to it being in a will. So we have clients that'll come back 5 years later and say, oh, my sister moved out of state and I really don't think she can be a guardian anymore. I want to update it so we can just create a new document. Temporary guardianship is basically you can still name it in the appointment of guardian or you can name it in your will, but it's designating a person who would take legal or temporary custody if the parents have been deceased or are incapacitated. So what I mean is rather than just the permanent guardian, my example, brother coming in and taking my daughter, if my brother is in Oregon out of state and I want to name a temporary guardian like my neighbor who I know can be there in an emergency right away, then I can name a temporary guardian to kind of step in that emergency. Again, it's permanent guardians being out of state or out of the country is when we really like to use the temporary guardianship. Other essential estate planning documents, I call these the living documents. So I call them living documents because they matter while you're alive. So there's a general durable power of attorney, which is a financial. There's a medical power of attorney, and there's also an advance directive or living will. So we'll talk a little bit about each of those. The first is the financial power of attorney. So this is often referred to as a general durable power of attorney. It's basically finances and everything that's non-medical. So think like managing bills, real estate, bank account, taxes, insurance, um, loans, anything like that, even if you're not named on an account. It is only valid while you're alive. So again, that's why I call them living documents. If you have a power of attorney and you appoint an agent to act for you on your behalf, if you pass away, the document's no longer valid, right? Because they can't act for you if you are no longer living. Some special considerations to think about when you're doing a power of attorney for finances is whether you want that document to become effective immediately or only after you are incapacitated, which is called a springing power of attorney. We often recommend for our clients who are, married or naming a adult child or a sibling that they trust to have it become effective immediately because most of the time it's going to be an emergency situation where you want that person to be able to act right away rather than wait for a doctor or a physician in the middle of the night declare that person to be incapacitated. So oftentimes we like to do that immediate because we see these most often in an emergency. The other thing that I mentioned in the beginning is just because you're married, it doesn't mean that your spouse gets to be your power of attorney. You actually have to have a document that says your spouse is your power of attorney. And then you might name a backup. I like to use the example of when I'm trying to like pay a bill or fight with Comcast and I get on the phone and I'm trying to get information and they're saying that it's not under my name and that they can't give me information without hearing my husband, give the okay or getting him on the phone. So if it's that hard to talk to Comcast, imagine what it would be like to try to deal with a bank or any type of financial institution if you don't have that power of attorney. Co-agents is another thing. Usually for couples, they don't name co-agents as a primary agent, they'll name their spouse. But for my older clients, like with grown kids, they might name both of their daughters as co-agents. And so that can work as long as the people get along. If you have co-agents, right, that don't get along and there's going to be conflicts, it's really not a good idea to name co-agents. So that will really depend on your specific situation. You also want to avoid adding family members to bank accounts. I talk about this a lot of times with my older clients, and some of you might have aging parents. Some of you might be aging adults. And by naming someone on your bank account, there's a difference, right, between naming someone who's an authorized user and actually an owner on the account. So if I name on my account my brother because I want him to be able to like act for me, if he's a joint owner, when I pass away, everything goes to my brother. If I don't want that because I want it to go to my children, for example, then I don't want to add him to my bank account. So a power of attorney is a way to allow someone to access your bank account and pay your bills and kind of be that authorized user without giving them all of the money when you pass away. A medical power of attorney, pretty obvious, right? It's basically designating an agent who's going to handle your healthcare decisions while you're alive. So this person can make medical decisions for you if you're incapacitated. Usually we don't have like a springing power situation here because if you can talk and you're alive and well, then you're calling the shots, right? Like you're the person talking to the doctor, you're the person saying, yes, I want that treatment. No, I don't want to go to that rehab facility. But we do have situations like after an accident, if you're a little fuzzy, concussion, other things, or you're overwhelmed and you want your agent to be able to be part of the decision making, then you're basically going to vocalize that and say, yeah, talk to my husband. I'm not really sure what I want to do. And if you're incapacitated, then that person is really just going to take over and act in your best interest and advocate for you. Some of the things that we see and we kind of call out to people to think about when they're naming an agent for their medical decisions and medical power of attorney is you want to make sure your agent understands your wishes and is okay and like comfortable with those wishes, right? So if you're someone who doesn't want life support and doesn't want like extreme measures taken at end of life, you want to name an agent who is going to honor that, right? And be okay with that. If it's going to be someone who's super emotional and not going to be able to do that, then you should think about that and make sure you name someone who's on the same page as you. That's why it's really important to discuss that with your agent before you designate them. And again, we always recommend naming that successor. So if you're married and you name your spouse, well, what if you're both in an accident together, right? Who's going to be that backup that's going to come in and talk to the doctors and make those decisions? Co-agents, the same thing. A lot of times people like to do it if they have grown kids or they want to name two people. Sometimes, like for example, I just talked to my mom about this. My dad is super squeamish. He does not like hospitals. He is like terrible in emergency situations. So my mom and I talked about changing her power of attorney to name me and my dad as co-agents because then we can act together and it's not too much for my dad. So that's another example of when co-agents could be a good idea. So your advance directive, another name for that is a living will. This is really a document about end of life decisions. So the medical power of attorney is going to come into play before end of life, right? Like gray area accidents, we're trying different things, a temporary situation where someone's going to get better. But the advance directive comes in when you're terminal, when you're in a vegetative state, neurocognitive illnesses, and your body's really shutting down. So at that point, you want to have a document, right, that says how you feel about life support. Like, do you want a machine to keep you alive? Do you want a certain amount of time for family to come and say goodbye? The document also includes HIPAA. So even if you have your spouse as your decision maker, right, your agent, you might still want your parents to be on HIPAA so they can call the hospital and find out what's going on. You can also include your organ donation preferences. So a last will and testament, um, it's funny because a lot of times people will say like this is the foundation of an estate plan, but it isn't necessary all the time. That's a little outside the box. Sometimes people hear me say that and they're like, what? I think everybody needs a will. But the reason I say that is with a guardianship and your powers of attorney, if you have not a blended family situation, you are married to your spouse and you have kids together, then the basic laws will say if you both pass away, then all the assets will go to your kids. And so a lot of times, we start with couples and say, you know what, let's just get the guardianship done because that's the part that's important, but it doesn't really matter who's going to be in charge of the money. So let's talk about guardianship first. Last will and testament is important, but it doesn't just deal with guardianship. It talks about who's going to be the executor. We call it a personal representative here in Colorado. Who are the beneficiaries? You can name a guardian in addition to that standalone document, but it only comes into play after you pass away. So if you want to control like who's in charge of the money and when your kids get the money and that they don't just get it at 18, that's where you want to use a will, right? And so a will can be important, but a lot of our clients who are kind of starting out will say, well, let's just start with a guardianship and those powers of attorney. And then we can, do the will in a few years. We'll save up for it as we get more assets. And so that is, again, like more of an advanced plan. With our clients with minor children, the type of will that we do is a will with a testamentary trust. And that's just fancy for a trust within a document. So you're not actually creating the trust now. What you're doing is laying out the framework of the trust in the will. So it will say something like, I give everything to my spouse as long as my spouse survives me. If my spouse does not survive me, then I give everything to my children equally, so long as they're 25. If they're not 25 when I pass away, then a trust will get created. And this person, the trustee, is going to manage the money until they turn 25. So again, you're not creating the trust, you're just building it into the will. because in all likelihood, you're going to live a long and healthy life and your kids are going to be beyond 25 when you pass away and they'll just get it outright. But you do want to plan for that emergency or that situation that you're not anticipating. And so you can name a trustee to manage the assets and kind of decide on when they get it, right? Like, do they get a certain amount when they graduate college? Do they get a certain amount at 25? So you can kind of pick and choose when that trustee is going to be giving the money to the kids. Don't wait until it's too late. Big message here. Basically, you want to protect yourselves and your families by executing these types of estate planning documents while you still have capacity and you're not in the middle of an emergency. I do get calls from clients who are in the hospital or, diagnosed with cancer, and suddenly they have to worry about these things. And so we don't want, in the midst of all of that, to be worrying about your power of attorney, right? Or your guardianship document. So it's really important to take the time, even though it's not a fun thing to talk about, um, to do it while you are alive and well and have capacity. Because if you get to a point where you're incapacitated, you can't execute those documents, right? And so the family can't execute those documents for you, and you get to a point where it's too late. So a lot of times, if we're in that situation, a family member will have to go to court and have the court appoint them as a conservator to manage assets, or a guardian to manage, children or adult children who are disabled. So it's really important for you yourself to execute that document when you can. What happens if you die without an estate plan? There's a super complex chart. The law just changed recently. So it's something that I talk about with clients. I'm not going to go into a lot of detail because we're just kind of talking about the essentials right now. But basically, if you have assets over $82,000 in Colorado, and that number's creeping up with inflation, then probate is required. Remember, even if you have a will, if you have assets over $82,000 that don't have beneficiaries, right? Like, I'm not talking about a 401k that has a beneficiary, but if you have a bank account, or if you have an investment account and you don't have a beneficiary on it, then it is going to trigger probate. And if you don't have a will, it is going to follow intestate succession. And intestate succession is basically the law of the state that is that complex chart that I kind of described. Who gets what, depending on, do you have children? Do you have a spouse? Do you have parents? And so it's pretty complex. As I mentioned, the basics, if you have kids and the kids are with your spouse, then everything goes to your spouse and then to your kids. So if you're okay with that, again, a will is not like the most essential first step. But if you have a blended family or kids from a separate relationship, and things are a little more complicated, then a will is really important. So I always am very transparent about my pricing. Like I said in the beginning, sometimes people get intimidated, or they're like, oh, lawyers are so expensive. I don't think I can afford one. And so I just put this out here. Some of them are like starting packages, and so they could get more, but just to give people an idea, our standalone guardianship, again, that standard, like, separate document where you get to name a temporary guardian, and a permanent guardian, we charge $350. The living document, so again, that's going to be the powers of attorney, so medical, financial, and advance directive, is $750 for an individual and $1,000 for a couple. So you'll see, like, couples that work together kind of get that discount because a lot of times those documents are similar. Will packages start at 1,500, 2,200 for a couple, and then trusts, are closer to 3,000, 4,000, and above. So again, it's a big range, which is why sometimes we say start small and, like, get that guardianship document in place if you have minors. A few takeaways. I know we're running out of time. Everyone needs an estate plan. The sooner the better. That's certainly my opinion. And start small, right? You can always update it. We tell clients, like, every 3 to 4 years, you want to revisit. If you have a big life event, like if someone passes away, you get divorced, someone, gets dementia or a disability, then you want to revisit it sooner. But generally speaking, right, you can look at it every few years. And so a lot of our clients will just say, let's start with that guardianship. Like, let's get a guardianship, let's get powers of attorney. And then they'll come back in a few years and say, okay, I think we're ready to do a will. Like, let's add that. Or, you know what, we bought a rental property, or we have property out of state, or we just inherited something from, our family. Maybe we need a trust. So it's something you can build upon. Again, what you need depends on your specific situation, and DIY estate planning can be okay, but it can also go wrong. So it's really important to take advantage of professionals and work with them and at least get their opinion and educate yourself before you try to do it on your own. If you have minor children, like I said, I've stressed so many times, appointing a guardian in a standalone document or a will is the only way, right? You get to control who has custody. So you can't control everything, but you can control who is going to be the guardian if you complete that document. I think that's it. Sorry, I was talking a little fast at the end, but I'm happy to take any questions. I also offer free consults, like I said. So here's my contact information. I'm happy to share the PowerPoint slides afterwards by email. Again, I'm really big on education. And so I just want to be able to make people understand that this is scary, but it's important and it doesn't have to be more complicated, right? You can start small and just make sure you understand how it's going to work.
Thank you so much, Rachel. That was very informative. I definitely had a lot of takeaways.
Good,
Um,
good.
I think that the main thing is just start small. It's okay to not know where to start or what you need to do, and that's kind of the purpose behind some of this education that we're going to provide. And start having those conversations. Start having those conversations with your loved ones, whether it's in your immediate family or spouse, or maybe children or parents or friends and family, so that it just becomes less of a scary topic and more approachable, and that you're better prepared for the future. So thank you everybody for joining us. Thank you so much, Rachel. These are going to be recorded, so I will have the information available in a little while. If you do want to rewatch this, that will be available to you, and you'll also be able to share it. So reach out to me. It will probably be just a little bit before we get them up on the website. But again, Rachel and I are both in sync in our desire to provide the information and get it out there so that people can be more prepared.
Jolene, I think I saw did you raise your hand? Do you have a question?
Hey, thanks so much for sharing this. No, I was just giving a little clapping sound, like thanks so much. I popped on
Oh,
at about 7:10,
I still
so
can't figure out the Zoom things. And I'm like,
it's
is that a
okay.
wave? Is that a hand? Is that, but I will take the
Yeah.
clap.
Hey,
Absolutely.
yeah, that's all right. No problem. I appreciate you sharing all this with everybody.
Of course. Thanks for
And
coming.
I'll give Jolene a little plug too, since she's on here. She is actually going to be our guest next month. And she is going to be sharing some tips and tricks for the emotional side of dealing with end of life preparation, or just kind of other complexities that come with losing a loved one, or just navigating all the psychology that goes with that as well. So we look forward to having you on next month, Jolene.
And Nicole, can you remind everyone the date so I can get it on my calendar?
So
The
it's the
next
third
session.
Thursday. This will be August 15th at 7 p.m.
Great.
So we'll make sure to blast that out to you. But I really appreciate everybody taking some time out of their busy evening to join us tonight. And thanks again, Rachel, and we'll see you next month.
Thank you. Good night.
Thank you. Good night.